On May 2nd, 2025, Michigan driver Ron Doyle Glenn was charged with 8 traffic violations, 5 civil infractions, and 3 misdemeanors. Civil infractions can be paid or contested, but misdemeanor charges require a formal court arraignment. Mr. Glenn was scheduled for both an arraignment and a civil infraction hearing on June 6, 2025, but he did not appear. As allowed under Michigan law, default judgments were entered on the civil infractions, but criminal charges cannot receive default judgments. Instead, a show cause hearing was set for August 19, 2025, requiring Mr. Glenn to explain why he missed court and why he shouldn't face penalties. Mr. Glenn was then charged with 4 more traffic offenses on May 21st, including driving with a suspended license. He again missed his July 3rd arraignment, leading to another show cause hearing scheduled for July 28th. He also skipped a July 7th civil infraction hearing, resulting in another default judgment. On July 28th, Judge Shada Perkins held the first show cause hearing in the 36th District Court's virtual courtroom. Mr. Glenn appeared via Zoom, represented by attorney Phyllis Gann Robinson.
Are you driving, sir? Mr. Glenn, Rondell Glenn?
Yeah, man, I'm sitting out in the sun, buddy. I'm trying to grab me something to eat.
All right, don't drive in court.
I'm not going to be driving, buddy, when I'm in court, all right? Just call me.
No, listen, I'm not your buddy, okay? First of all, but at the end of the day, if you're driving right now, you're not supposed to be driving, okay?
Yeah, but how long am I going to be sitting here? I haven't spoke to no defense attorney.
I don't know how long you're going to be sitting there. You're waiting. If you came on time, you would have heard me. I said I'm going to try to get you out as fast as I can.
It's all good, man. Listen, it's all good.
Listen, don't cut me off. Are you driving your car right now?
I'm going to park my car, but, man, I can't be sitting out in the sun.
I'm putting you out of the room.
Put me out of the room?
Yes, for driving in court. All right? Come back when you get in a safe location.
Attorney Gaten Robinson on behalf of Mr. Rondell Glenn. Mr. Glenn, please state your name for the record.
Mr. Rondell Glenn.
Your Honor, I don't know how many tickets that was you just read off. I only have 3 on my docket.
Yeah, Mr. Glenn doesn't have any respect for the court. I see he's exhibited disrespect for the court, and he's
wait a minute, hold on, wait a minute. What you talking about?
You wait a minute. You wait a minute.
I'm going to the judicial tender commission.
You wait a minute.
I don't want you to remove yourself from my case, bro.
Listen,
I'm 58 years old.
That's the disrespect.
I don't know what it is about me and you, bro.
That's the disrespect.
Mr. Glenn, can you please be quiet for one? Mr. Glenn, as the attorney who's trying to help you, can you please be quiet for a moment? The first issue that you have is you should not be driving on Zoom. Park the car, please. You cannot drive on Zoom. This is the definition of distracted driving.
He should not be driving at all. He's already indicated to the court that he's driving when he was driving while in court. I asked Mr. Glenn that if he's driving, he said he's driving to go in to get something to eat, I believe. So now
Mr. Glenn wasn't driving. Somebody was driving for me. I'm with somebody. What do you mean? What do you mean, man? I'm 58 years old, bro. Look.
Mr. Glenn, I'm trying to help you. Can you please just wait a minute?
All these tickets from 20 years ago when it's only 3. You know what I'm saying?
Sir, stop. Mr. Glenn, stop so I can help you. I'm trying my very best to help you. You got a chip on your shoulder, but it's not. Sir, give me a minute. I'm gonna try to take you in a breakout room and talk to you before you make your circumstance worse. Just be quiet until you get there, please.
Yeah. Okay.
Thank
you. Mr. Glenn, after you finish talking to him, I'm gonna give him a pre-trial date for tomorrow. Mr. Glenn has to come into court in person.
Fine. I'm going to the Judicial Tender Commission because you're very impartial. You're not about to try to embarrass me in court like that, man.
Glenn, stop. Mr. Glenn,
we only got 3.
Just ask you to be quiet so I can help you.
I'm going to file a complaint today.
That's fine. You can do whatever you want, but
you're not about to try to embarrass me like that, be disrespectful to me, and think I'm gonna sit up and take that.
Mr. Glenn, Mr. Glenn.
And they come to court properly dressed. Don't come to court in a sleeveless shirt. Come to court properly dressed.
Your Honor, can I please have a moment to talk to Mr. Glenn? I muted you because you're not making it better. Just be quiet.
It doesn't matter what you say to him. He's going to take an anger management class too.
Your Honor, I'm going to move Mr. Glenn to another breakout room.
Very good.
He's the Motorola device.
Yes. Move past the matter. Tell them to come to court properly dressed, Ms. Gaten.
Mr. Glenn, you should have a prompt to go to breakout room 5. Go to breakout room 5. Look at your device, Mr. Glenn. You should have a prompt on your screen to go to breakout room 5. Just click OK. All right, Mr. Glenn, I'm going to send you a different prompt. Just when you see the room number pop up, please just click OK. You're going to room 8.
All right, let's pass
just
the matter.
Click OK.
Gaten Robinson, are you still dealing with Mr. Glenn?
Your Honor, Mr. Glenn was not the easiest to try to talk to or get to reason with. He has indicated to me, is he still in the breakout room? He told me he was coming down to the court today. He doesn't understand why he has to come tomorrow, so he's coming down to talk to the chief judge today, which I told him that is absolutely his right. He could. He felt like you were picking on him by calling out his older tickets. I explained to him that that is your process and the process of many judges down there, that when people have outstanding matters, if they are on your docket, you will pull all of their matters in an attempt to be efficient. And you've done that with multiple clients of mine this morning to try to reassure him that that was not you picking on him. He didn't understand why you were bringing up old stuff. So I explained to him that that's you trying to be efficient because he had multiple tickets in front of the court outside of the 3 that were on the docket.
Ms. Gann Robinson tells Judge Perkins that Mr. Glenn was offended when the judge called the May 2nd misdemeanor charges along with the other pending misdemeanors. She explained to him that the judge grouped all active charges to promote judicial economy, meaning efficient use of court resources so cases are resolved quickly without unnecessary duplication. Since Mr. Glenn had another show cause hearing set for the following month, Judge Perkins called all pending charges together to handle them in one proceeding rather than repeat the process later.
I indicated to him that he was supposed to be here tomorrow at 8:30 in the morning.
He's here.
I got his attention. He's aware that we're trying to pull him back into the breakout room. I'm about to send him a prompt. To the main session. I'm about to send him a prompt.
I'm trying to get him in the main. Stop close the rooms.
Okay.
Now, if he keeps it up, he'll find himself in contempt.
Your Honor, I'm trying to save him, but.
And I know it's probably going to be ordered as a transcript. So can y'all please talk at one time at a time?
Well, good luck. Good luck. You can get the video.
Sure.
All right. Let's go back on the record with Mr. Glenn. Mr. Glenn, let me say something to you, sir. Start your video, please.
I got it going. Get it straight now. Get it straight, bro. I simply wanted to come in and plead not guilty.
But Mr. Glenn, I asked you to stop talking to the judge like he's your friend or somebody on the street. You would not talk to another judge in a different jurisdiction like that. He's not your bro. He's Judge Perkins.
Now let me stop. Let me stop right.
I'm trying to help you, Mr. Glenn. You making it worse.
Stop, Ms. Gaten Robinson, please. Mr. Glenn, let's get this understanding. First of all, I'm not your bro, okay? Yeah, I'm the judge, Mr. Perkins, but I'm not your bro, okay? Second,
I know you're not.
I didn't ask you to speak. Don't talk while I'm talking. Secondly, if you continue to act out like you've been doing, I'm gonna have no choice but to hold you in contempt of court, okay? And I don't want to do that. I'm trying to exercise the utmost restraint with you.
Judge Perkins reprimands Mr. Glenn for calling him bro and repeatedly interrupting him, warning that this behavior could lead to contempt of court. Under Michigan law, section 600.1701, judges may hold someone in contempt for misconduct during proceedings, including disrespectful, disorderly, or disruptive behavior that interrupts the court or undermines its authority. Addressing the judge casually and repeatedly talking over others could be seen as disrespectful and disruptive, meaning Mr. Glenn's actions could have justified a contempt finding.
Now, third, I called those cases into the record to be as a matter of judicial economy. I don't know when you got those tickets. I don't care when you got those tickets. I try to do that for the benefit of you so you don't have to keep coming back to court multiple times and you don't have these warrants sitting out here on you, okay? That's why I called those cases. into the record. That's my choice to do that. And I called the cases into the record for the court and for your benefit, so you don't have to keep coming back to court. Okay? So
I appreciate
that. I'm gonna let you speak. Let me finish. You're gonna come into court in person tomorrow at 8:30. I want you properly dressed. You can say what you want to do what you want to say. If you don't appear, then a lot of people don't show up. That's what the court has to say. Now, you want to talk? Go ahead and speak.
Judge Perkins instructs Mr. Glenn to dress properly for court. The 36th District Court dress code prefers casual business attire and prohibits shorts, cutoffs, sleeveless shirts, and hats not worn for cultural or religious reasons. Courts can lawfully enforce dress codes as long as they are reasonable, neutral, and maintain courtroom dignity. For example, in Bank v. Katz 2009, the U.S. District Court ruled that attorneys do not have a First or 14th Amendment right to wear jeans or hats in court. Judges can set limits on courtroom behavior and attire to preserve decorum, and courtrooms are not considered public forums, so reasonable, neutral restrictions like the 36th District Court's dress code are allowed.
Okay. So I'm sorry about calling you bro. Okay. But I didn't think that you would get impartial and start, you were supposed to be here early. I'm 58 years old. Okay. So I'm kind of tech challenged, but I called down and I got in. Okay. I was late, but I got in, but it's just the way you was talking to me, that had me like, damn, like, I don't really want to go in front of this guy here, man. Plus I know Todd. So that's another reason why. Okay. So I was just asking if you could just recruit yourself. Then I found out some other stuff that's something, that's going on. Some news is going on right now. I don't want to be a part of that. I just want to go to another courtroom. If we could do it like that, then we good. Then I don't have to go down to the Judicial Tender Commission, file a 3-page report. You know what I'm saying? Just recruit me from your courtroom. That's all I'm asking you.
So, Mr. Glenn.
On the grounds of, maybe not because I don't think you're impartial, but...
Let me finish. Let him go ahead and finish.
Okay. Maybe not because I felt you were being impartial, but let's not say that. But I do know Todd personally. Been knowing Todd for a long time. So that's another issue. Not the other issue about what's going on with you now, but I'm just asking the court, please, just recruit yourself or just send me to another judge, and I appreciate it.
All right, let me. I'm not going to send you to another judge. I want you to come down tomorrow morning at 8:30. I accept your apology about the bro situation. I didn't hold you being late against you because I did let you in the room. As long as I'm sitting here, I question why people are late. I understand now why you're late. You told me you're not as tech savvy as other people, and that was it. You also were driving in court. You admitted to that. You have a
no. Let's clear that up. Listen, I have a business.
It's cleared up in the court's eyes. It's all being recorded. It's on transcript. You admitted to that. Okay. So
you can say whatever you want.
I let you speak. Speak, and I'm speaking. I said, do not interrupt the court. All right. So this is it. We're not gonna keep going back and forth. I'm gonna let you go about your day, but come down tomorrow morning in person, and you can go to the Judicial Tender Commission. That is your full right. You can go to the chief judge, but I'm not going to sit here and have you yelling at my staff or anything, okay?
After admonishing Mr. Glenn for driving during court, Judge Perkins required him to appear in person the next day. While Michigan court rules don't explicitly ban driving during virtual hearings, under Rule 2.47, judges may decide a case is not suitable for video conferencing. Factors include whether participants can maintain courtroom dignity and decorum, or whether virtual proceedings would undermine fairness or effectiveness. Judge Perkins exercised this discretion, concluding that due to Mr. Glenn's actions, the hearing was better handled in person.
Your Honor,
listen, I'm not a
Mr. Glenn, please give me one moment. Please, I've been begging you since the beginning of our interaction. I'm trying to help you. Just be quiet.
Right. I should have brought my boy Blake in here. I wouldn't have all this.
Okay, so one moment, Your Honor. I explained to Mr. Glenn that he does have to be at court tomorrow morning at 8:30. I did also indicate to him that it's his absolute right to retain an attorney. If he is not able to retain an attorney, then he can ask for an appointed attorney tomorrow. Because he is here for misdemeanor matters, he is entitled to counsel. If he wants to pay his own counsel or ask for counsel tomorrow, that is his right. But I'm making it clear that Mr. Glenn is aware of his right to have counsel tomorrow at court.
All right.
If Mr. Glenn come to court, he coming with all the news coverage. Okay, so we just want to make sure everything
no
is good.
We'll see you in the morning at 8:30. Make sure you look good for the news.
I wanted a judge, and I make it with another attorney.
Okay. One at a time. Court reporters.
Put your good suit on. We don't care about you coming with the media. Look good for the media. Put your suit on.
I don't want you. You know what? As a matter of fact, you're on ineffective counsel too. So I'm good. I'm going to reschedule that.
Have a wonderful day, sir.
Let's handle it.
Stop it, Miss.
Have a wonderful day.
Don't say any more, Miss Robinson, please. Mr. Glenn, that's it, okay? I'll let you make your record. Come on down tomorrow morning, all right? Yeah, you're muted. You're muted now. Unmute him, please. Unmute yourself. Unmute yourself. All right.
Let me do what I gotta do. Okay, yeah. All right, bye-bye.
Some luck to you, sir.
Yep, take care.
Mr. Glenn missed the rescheduled in-person hearing, leading to a bench warrant. As of writing, his show cause hearing is set for August 19th, 2025. This case shows the difference between civil infractions, which allow default judgments, and criminal charges, which require personal accountability. The hearings also highlight the court's authority to maintain order through contempt powers, dress codes, and in-person requirements. Judges consolidate cases for efficiency, but defendants may perceive this as unfair. Mr. Glenn's driving during a virtual hearing and confrontational behavior demonstrate how a defendant's actions can worsen their situation.